Hi, good afternoon, everybody. My name is Alexander Rufus Isaacs, otherwise known as Zan, and I am your interviewer today. Welcome to the latest edition of War Stories, which is a series provided by the litigation section of the Beverly Hills Bar Association, chaired by Rudy Lehrer and Rachel Kogan. I'm a member of the section, and I'd like to encourage any of you who are interested in participating to please come to one of our section meetings and help us to plan and present future programs. Thanks too to our sponsors who are listed in the materials, which you should have already received a link via email. And a brief apology, I'm afraid my scanner misbehaved and not all of the pages of the transcript of John's opening statement and cross-examination of Donald Trump are included. If anybody wants a full transcript, let me know and I will do my best to scan the additional pages. So today is a very special War Stories for two reasons. Firstly, John Scherer is one of our preeminent trial lawyers. He's lost count of the number of cases he's tried. And because he's been at Gibson Dunn his entire career, the cases he's tried have not been rear-ended. They are enormously varied and complex, and in some cases going on for months. Secondly, from a personal point of view, John is a very dear friend of mine who's been incredibly kind to me over the past 20 years. When I mention his name to people who know him, their reaction is always the same: what a marvelous lawyer and what a charming and honorable man. So I'm very much looking forward to today, and I'm very glad that you're all here with us. If you have any questions as we're going through, please put them in the Q&A, and if we have time, I will put them to John. And without further ado, welcome, John Scherer.
Thank you.
So first question, John, which part of Texas are you from?
Well, I come from the same country as you do, Zan. However, my accent has faded somewhat. I come from the other side of the rail tracks than you do. In fact, when I was in London, my accent was like, "Hello, how are you? All right?" I was a bloody Cockney, don't you know? But my accent has faded. The only time it returns is actually when I am trying cases, and that is not because I'm putting it on, but because I'm so conscious of the words I'm saying, it becomes more pronounced. And of course, Americans believe that people with English accents are more intelligent than most, which of course is not true, but I've never attempted to disavow that position that they've taken. Has got me into trouble occasionally. The word Nevada does not come easy to me. I was trying a case in Las Vegas and was told by local counsel, "Don't call this state Nevada. Whatever you do, it's Nevada." Well, Nevada doesn't come easy to me, and was trying a case involving the Nevada State Gaming Commission. And I did okay in opening statement for most of the time, but a Nevada slipped in there. And I could see the chagrin looking at the jury, and I reminded them of a story that was true, that there was a classmate of mine in law school from Brooklyn who swore blind if they shook me real hard when I was asleep, I'd talk just like them. Never tested, however.
Let's go back to the beginning. What year were you born, John?
Oh, well, don't tell anybody. 1932.
And where were you born?
I was born in Charing Cross Hospital in London, my only touch with the West End.
And your family was from where?
From England. They were born in England.
And you brought up in Hackney, were you not?
Yes, I lived most of my life that was spent in London, in Hackney, which is in the East End of London.
And what sort of an area was that?
Well, it made East Los Angeles look like Beverly Hills, I think. It was not the smartest place on the face of the earth.
And there was yourself and your father and your mother and your sister, correct?
That's correct.
And what happened to your family when the Second World War started? You would have been 7 years old at the time.
Yes.
Were you evacuated?
No.
So you
No.
stayed in London throughout the Blitz?
For most of it, yes.
And your father, was he in the forces?
Yes, he was a major in the British Army in the Middle East. He was at Alamein.
Do you remember anything of the bombing?
Oh, yes, very, very clearly. Very clearly. The bombing, the V1s called the buzz bombs, and the V2s, the rockets. Yes, I remember them very clearly. At that time, as a child, I could identify the type of plane just by hearing the engine passing over. Now I can't recognize them even if I look at them.
And what happened to your family towards the end of the war?
Well, my mother died shortly afterwards, and my father became disassociated from us, and we didn't see him much again. And my sister and I lived by ourselves for a while until we decided to come to the United States to see if we'd like it.
So at the end of the war in 1945, you would have been 13, your sister would have been 16, and you were essentially orphaned, living, in Hackney with nobody looking after you. Is that correct?
Yeah, we didn't think we needed anybody to look after us. We were doing okay.
And the other thing I have to ask you about this period of your life is you had an affinity to a certain football club, or as we should say here, a soccer club. Which club is that, and what is your association with it?
Well, Chelsea in what was then the first division, they didn't have the Premier League. I had a brief association with what is now the academies. It was more loosely just a kick around and seeing the big players. But by the time I got there for a few weeks, I was ready to leave for the United States. I was
you were
a goalkeeper.
You were a goalkeeper, were you not?
Yeah. Yes, I was.
And in those days, the balls were very heavy and got waterlogged. Didn't that cause some problems when you were trying to catch the ball?
Well, if you misjudge it, and I did on occasion, and it caught you on the end of the fingers, you end up with fingers that look somewhat like these, sort of gnarled and beaten up. I misjudged a few crosses in my day and suffered the consequences.
So after the war, when you graduated, you went to grammar school and you graduated aged about 16, I guess. Did you work in London for a while?
Yeah, I worked in the Haymarket for a real estate agent, mostly getting people cups of tea and coffee and collecting rents from the prostitutes on Shaftesbury Avenue, which is a little north of Piccadilly Circus.
This is all the West End, which was supposedly kind of now a kind of glamorous area. But I mean, in those days in London in the late 40s, it must have been a very grim environment to be living in, wasn't it?
Well, we almost starved to death. There was limited food. Yeah, my mother would leave. In those days, there weren't supermarkets. You shopped from the butcher store to the bakery, to the greengrocer, to the fishmonger, and took hours. And when my mother came back after 2 hours going from one store to the other, she had very pitiful amount of food with her. So there was no fear of being overweight.
Was there ever a question of you going to university in England?
It was difficult going to university in England when you came from the East End. When you had an accent like, hey, mate, you were immediately ruled out. There was a big thing about accents at that time. You couldn't join the foreign service and so on and so forth. So yes, I never actually thought of going to college when I still lived in England.
So you decided when I think you were 17 to get on a ship and come to America, is that right?
Yes. Yep.
And tell us about your early adventures when you arrived in the US. What happened to you? What were you? What was your aim when you came over? Were you thinking of emigrating, or were you just came over to have a look and see what it was like?
Well, I thought I'd go down the Eastern Seaboard, cut across the United States, see all the movie stars in Hollywood, and go back to England. But I had misjudged the amount of money needed for those adventures, and I ran out of money in, of all places, Jackson, Mississippi, at a time when it was total segregation. And I got a job running the elevator, rather poorly, I might say, at the Robert E. Lee Hotel in Jackson, Mississippi.
This would have been in what, 1950 or something?
51.
Yeah.
Yeah.
So what was it like coming from England, which, you know, for all its, unfairness, was not a segregated society, and then to go and hit the American South in 1951, was that a shock?
Well, it wasn't like going from one country to another. It was like going from one country to a different planet. They were supposedly speaking English, and I knew I was speaking English, and yet we couldn't understand each other. And while there was deep segregation, I didn't comply with it, not because I was a crusader, but because I just didn't think it applied to me. So in those days, they had black movie houses and white movie houses and black restaurants and everything was totally segregated. But if I saw advertised in the paper a motion picture that I really wanted to see at a black theater, I would go there. And if I had been a Yankee from the North, I'd probably got strung up. But because at that time still, the Southerners were grateful to the British because the British had essentially financed the South in the Civil War, not because they were in favor of segregation. They had done away with slavery many, many years before, but because they needed the cotton, and the cotton came from the South, so that's where the money came from. And they would say repeatedly when they heard that I'd gone to a black movie house or I'd had a meal in a black restaurant, that he's just a British kid, he'll learn better, which of course I never did.
So at one stage, the authorities caught up with you and gave you an ultimatum, did they not?
Yes, I got drafted, but I was still a British citizen. And they said, you don't have to go in our army. You're not an American citizen. But if you don't go in our army, you have to go back to England. And the problem with that is if I went back to England, I'd end up in the British Army. They had a draft. And I wouldn't have got the GI Bill. England didn't have a GI Bill. And their British uniforms were not nearly as smart as the American uniforms. So I decided I might as well stay and go in this army. And it did lead to my going to college and part of law school on the GI Bill.
So you first arrived in Los Angeles, did you not, before you went into the army, shortly after you left Jackson, Mississippi? You arrived by Greyhound bus on some, anonymous day in 1951 or 1952, and you stayed here for a year or so, did you not, before you actually went into the army?
That's true.
And what did you do in that year?
I had a job working on the loading zone of American greeting cards, loading packages of greeting cards and sending them off to various retailers. Very dreary job.
And so then you went into the forces. I believe you were stationed in Germany for most of the time. And
yes.
If we skip over that, then you came back and you were able to go to college on the GI Bill, is that right?
Right.
And where did you go?
Well, I first went to Santa Monica College because I didn't have the reason for being in the state that long. And then I went to UCLA, but for some reason I've never fully understood, I was able to finish undergraduate school in 3 years, not because I was smarter than anybody else, but I was given 8 units for having gone to high school in England, which didn't really say much for the American education, but nonetheless. And I got 8 units for having been in the Army, which surprised me because I didn't think that being able to field strip a machine gun was worth 8 units of credit, but I accepted it and took it. So I was able to get out in 3 years.
And you also picked up a girlfriend when you're at Santa Monica College, correct?
I did.
And are you two still together?
62 years later, we're still married. We've got no imagination, I suppose.
I love your wife. Margie is the most wonderful woman. So then you did UCLA Law. You did pretty well at UCLA Law, didn't you?
Yes, I did. I was on the law review and was order of the coif, which I think, I'm not sure, is limited to the top 10% of the class or something like that, or 5%, I'm not sure.
Had you always been a hard worker? I mean, you know, to distinguish yourself in that way, you must have really hit the books. I mean, was it something that came with studying, something that came naturally to you?
I'm sorry, Dan, you broke up.
Was studying and working, you know, flat out at law school, was this something that came easily to you? I mean, you'd left school at 16, you'd had this break, and then you're back into the college system. Was that an easy transformation, or were you used to it?
Well, my nephew, who years later went to the same high school that I went to in London, Central Foundation School for Boys, ran into the sports master and said, you may know my uncle. He went here, John Shearer. He said, I remember him. Very good goalkeeper, rotten student. Both of which were true.
But then something happened to you, and you got this appetite for studying. You work really hard. You do really well at UCLA, and then you're recruited by Gibson Dunn, having been a summer associate there. And what year did you join Gibson Dunn?
61, the year I graduated from law school.
And you've been with them your entire career, correct?
I have.
Have you ever been tempted to move to another firm or to go on the bench or do something else?
Oh, several times. I got offers from plaintiffs' firms, and I got an offer to go on the bench, but I didn't think that was for me. I like to remain on the side of the bench that I've gotten used to.
Within a short space of time, having joined Gibson Dunn in 61, you started getting sent out to try cases fairly soon, did you not?
Yes, I was trying cases very early in my career.
And did you have a particular angle at that time? Was there any particular type of legal issues that you were concentrating on?
No, not really. I think I was somewhat unusual in a big firm. Big firms don't try a whole lot of cases, and when they do, they're mostly big antitrust or similar type cases. I was trying all kinds of cases: personal injury, wrongful death, antitrust, breach of contract, dispute between Buster Douglas and Mike Tyson, and all kinds of cases. There was no
particularly,
limit.
I think professional liability was one class of cases that tended to go to trial more than any other class at the time, correct?
Yeah, I tried a
was that?
lot of medical malpractice cases and quite a few legal malpractice cases and a few accounting malpractice cases also.
And why did they tend to go to trial?
Well, unlike automobile accidents where the insurance company can settle you out without your permission, professional liability, particularly lawyers and doctors and hospitals, cannot be settled out without their permission. And doctors were always convinced that they've never done anything wrong in their lives. So they rarely, if ever, gave consent to settling a case. I can't remember more than 2 or 3 medical malpractice cases that were actually settled before they went to trial.
One of the things I did to prepare for this program is I did a Westlaw search on your name, and Westlaw only really pulls up appellate cases, but there were over 40 hits going back to 1965. And what struck me about them, just glancing through them, was the tremendous diversity of cases that you were trying, and they were up on appeal for one reason or another. Do you think this gave you an advantage, that you had a broader focus, that you had the opportunity to sort of, appear in different types of cases?
Yeah, I think so. I mean, the types of jurors you're looking for differ depending upon if you're representing a doctor or a lawyer. Jurors love doctors, they hate lawyers. Hate may be a bit extreme, but they look at lawyers not as the worst possible litigants. Sexual predators are the worst, litigators the second. So it is difficult to pick the same type of jury with different types of cases. And of course, the witnesses and the experts are totally different. It does give you a broad range.
You also have, in your career, you notice that some lawyers, and certainly on the litigation side, tend to be more litigators, and others, for some reason, tend to be more suited to trials and feel comfortable in trials and are able to communicate with jurors. Is that a distinction you've seen in your career?
I think really it depends upon more the type of cases that individuals are trying. Big corporate type lawsuits frequently get settled. There's an enormous amount of money at stake. And nowadays, well, I wouldn't say nowadays, but in the recent past, in the old days, you right before trial, the trial judge would say, "Any chance we can settle this case, fellas?" And the answer was no. Let's pick the jury. Now you can't get to trial without being assigned to a professional mediator, and frequently cases that wouldn't have been settled before are getting settled more frequently now.
Did you get a reputation within Gibson Dunn as to somebody who knew how to try a case, and you would therefore be pushed forward perhaps a little bit and do more trial work than some of the other litigation partners?
Yeah, I think I've probably tried more cases than anybody in recent history, at least. To my knowledge, I haven't canvassed anybody to find out, but I think I was in trial more than most.
And you are now, and you have been the last few years, been teaching trial advocacy and practice at various local law schools, correct?
Yes. I've been teaching trial advocacy originally at Loyola Law School, more recently at Pepperdine, and I coach Pepperdine Law School trial teams in local and national competitions.
And I wonder if we could maybe for a minute talk about, some of the lessons that you've learned over these amazing 60-year career, and that you've been passing on to your students in these, in these sessions, and also I'm sure your mentoring of young lawyers at Gibson Dunn. And so I want to ask you, if I may, a few more general questions about trial practice and preparation. I'd like to start off by asking your opinion on mock juries.
Yeah, mock juries are helpful, not overwhelmingly so, because there are drawbacks. The mock jury is attempted to be cloned for what would be expected to be the age, sex, nationality, race of a jury in the vicinity where you're going to try the case. It's very difficult to do. And furthermore, they're not hearing evidence, they're not hearing witnesses, they're listening to arguments about the case, and then they deliberate behind a one-way mirror, and we watch them. So my experience has been that they can be helpful, but not completely. I had one experience that taught me a lesson, although I thought I already knew the lesson. I was getting ready to try an accounting malpractice case, which I never fully understand. The facts were so complex. The accounting principle was so difficult. I kept calling periodically the partner at the accounting firm and saying, "Joe, give it to me again. I've lost it. And he'd explain it to me, and I barely hang on to it. So when we went to this particular mock jury, we gave our arguments, and some were taking notes, some weren't. The organizer said to me, I got one too many people in there. I got to remove one. And I said, well, what about that guy? He was we'd done a little voir dire. He was a black guy, but that had nothing to do with it. But he was a garbage truck driver. And he showed very little interest in when we were talking. Others were whispering to each other, taking notes. He just sat there, looked like he wanted to take a nap. And so I said, what about we get rid of him? And the organizer said, I need him for the ethnic balance that we're cloning the jury and nonsense like that. So I said, okay. So they started to deliberate. And as I expected, he sat there looking completely disinterested, didn't seem to react to anything. And I was just ready, and the rest of the jurors were discussing, and they weren't getting it. They weren't understanding what it was all about. I was just about to suggest to the organizer that maybe we ought to get on the microphone and reorient them in some fashion, when all of a sudden this guy jumps up and he says, you people are not getting this. Let me explain it to you. And he explained it in simple terms, and I'm going to emphasize simple terms. And I said, my God, that's it. I finally understand it. And it taught me a lesson I should have known a lot earlier. And that if you use the vocabulary, the language that the average juror uses, they will understand the most difficult of problems. The difference between education and intelligence are two totally separate things. You can have all the education, PhDs, doctorates, whatever, but that doesn't mean you are necessarily more intelligent than a person who doesn't have any real formal education. This guy was unlucky. He didn't get the opportunities that I got, but he was brighter than me, smarter than me, more intelligent than me. And when he was told in language that he understood, he got it. And it taught that the most important lesson that I could ever teach to anybody else. And that is successful litigation, successful trial work depends on one word, communication. If you're communicating in language, don't forget, you don't get a lot of CEOs and big time shooters and movie stars on juries. You get average people, many times old people, many times people who don't have much formal education, maybe none. But if you talk to them, not talking down to them, if you give them the understanding in the language that they're used to, not prior thereto and subsequent thereto, before and after, are much better words anyway, you'll get through to them. So if I can ever teach people to use the correct vocabulary without talking down, any lay jury, no matter how limited their education will get the point. So that guy, that garbage collector, did more for my career than that, because I totally bought into vocabulary, communication.
I think when reading your opening statement in the Don King Buster Douglas case, which we're going to come on to in a minute, one of the things that struck me is, firstly, how powerful it was and how well you expressed it, but the fact that you're using everyday language, you know, that you're not using terminology, and you know, you could see, I could see you presenting it, and you know, I could understand very much, you know, how powerful it is that, you know, the way that you use words and that you avoid jargon and, you know, in any way trying to dress up what you're trying to tell the people in fancy words, that you're very down to earth in your presentation.
Well, I must tell you one other vignette. There are a lot in California and other places of doctors who are also lawyers. How the hell they were able to sustain going to medical school and law school, I'll never know. But they are mostly plaintiffs lawyers. And some of them are very, very good. I've run into some of them. But very frequently, when they're examining their client, their doctor, or their expert doctor, they're talking to each other in language that only they understand, that nobody else in the courtroom understands. I've been asked frequently by people, how aren't you at a disadvantage when you're trying a medical malpractice case and the opposing counsel is both a doctor and a lawyer? You're not a doctor. I say, he's at the disadvantage. He has to try to remember not to speak in terms of medical jargon that nobody understands except doctors. So yes, communication is the key.
Moving on, let's talk about jury voir dire for a minute. What advice would you give to a young lawyer who's about to do his first jury voir dire?
If you're asking them individual questions, again, vocabulary, don't forget that. You want to communicate with them. If you ask questions of individual jurors, ask questions of all of them. Those that don't get asked questions can get insulted. Why wasn't I asked any questions? I had a lot of stuff to say. Mostly people think that what you're asking in voir dire is to get information as to whether this person has a bias one way or another, but you're not only should be getting information, you should be also giving information. It's the first time that the jury hears from you. And firsts are very important in trial work. When they first hear from you, they make up their minds about things early. That's not limited to jurors. People make up their minds about things of all kinds very early. So this is a chance to give them some information. Mr. Jones, if you hear during the trial that so-and-so, in other words, you get a piece of evidence in before the jury, you got to be careful. You may run across an objection, but there are very few objections in voir dire. And sometimes you get answers that you may not be used to. Incidentally, always use their names when you're questioning. You should have a sheet. You've written down number 1 is Mr. Jones, number 2 is Mrs. Smith. And when they get replaced, you cross them out, put the new person in. Don't say, juror number 3, blah, blah, blah. Don't say juror number. Mrs. Smith, could I ask you that? Always use their names, that's it. And keep your voice up throughout. It's a problem, and I'm gonna be candid with you. Women have more difficulty in a courtroom than men do, not because they're not as smart, not because they're not as good, but because their voices are higher pitched. Many of your jurors are going to be older people like me, and they don't hear higher pitch. That's the first thing that goes with older people is the higher pitch sounds. So women have to keep their voices up, speak slowly and deliberately, because they are at that disadvantage that can't really be cured. You've got to be ready for shock answers. I was trying a legal malpractice case on behalf of the defendant, and I asked Mr. Jones, one of the prospective jurors, Mr. Jones, what do you think about lawyers? And he said, I think that lawyers are leeches in suits. That's not too good. The judge calls us over and whispers at sidebar, I'm letting this guy go. Anybody got any problems with that? And obviously that would be a challenge for cause anyway. Off he goes. So Mr. Smith's the next juror, nice looking guy, middle-aged, well-dressed, looked like middle management. I said, Mr. Smith, did you hear what Mr. Jones said about lawyers being leeches in suits? Do you agree with that? He said, I don't agree with that at all. I thought, wow, I got a live one. I said, why don't you agree with that? He said, because sometimes leeches are useful. You know, you're taken aback, but you've got to recover. So I said, well, this has been a lot of fun so far. And they giggled and laughed, and we moved on. And of course, the judge immediately dismissed that guy too. So, yeah, you can't freeze on a bad answer from a juror. You got to laugh it off. You got to move on. So don't forget to make your chart with the stickers. And when you excuse a juror, when you get your chance to exercise your peremptory, don't say, number 3, get lost. That's not a good idea. Say, plaintiff will thank and excuse juror number 3, Mr. Smith, and smile at him, and off he goes, mumbling under his breath about what an idiot you are. But that's some idea about jury selection.
Let me ask you this. I want to move on because we're falling behind a little bit time-wise. How do you prepare clients for trial? What are your aims when you're sitting there and you've got a client who's going to trial?
Well, you want to go over the evidence with them. You want to make sure they are familiar with their deposition, had they had it taken. Have them read it several times. Explain to them that they're to answer only the questions you ask. The worst thing that can happen, not the worst thing, but one of the bad things that happen is you ask them a question and they ramble off into someplace. Not only does that risk an unfortunate thing coming out and a non-responsive objection being sustained, but you bore the jury. You got to have crisp questions and crisp answers, like a tennis match going back and forth. You don't want to give open questions that let them ramble, and you don't want to let them, so you got to teach them that. And you make a tape of a mock exam you do with them so they can watch themselves. It can be very humiliating to see yourself and all the quirks and things you do wrong. So that's important. And
what about likability?
Yeah, here's the more important thing, in my view, that has nothing to do with getting ready for the evidence or anything. It's how they come across personally. Make sure they dress properly. Make sure they don't slouch in the witness box. Make sure they don't fight with opposing counsel. Make sure they're respectful, that they make eye contact periodically with the jury. And whatever you do, don't look at me for answers, because that's a bad thing. And that is so important, because juries frequently decide things on what has nothing to do with the case. They decide things on whether they like you and your client and don't like the other guy and his client. And if you slouch and get dressed badly and fight with opposing counsel and look over at me for a hint and so on and so forth, you're going to be in trouble, which leads me to a rather funny episode that happened with me. I was trying for the plaintiff a wrongful death case. My plaintiff's husband was a worker and was killed in an excavation when it collapsed on him. And I'd finished my direct examination, and she was being cross-examined. And during the cross-examination, one of the jurors gave a note to the bailiff for the judge, and the judge called us in the chambers. And the note read, "What are we to think when the lawyer is trying to tip this witness off as to how to answer the questions?" So, my God, what have I done? You know, I'm purposely not looking at her. I'm making notes, and the judge says, "Well, have either of you seen or done anything?" And opposing counsel said, "Well, I don't know one way or another. He may be tipping off. I don't know." And the judge said, "Well, I haven't seen anything." So he goes back out there and he said to the jury, "It's been said that somebody's tipping off the jury. I haven't seen anything, and that's not going to happen and hasn't happened, and we'll get on with the case." Well, shortly thereafter, the jury retired. Evidence was finished. She was the last witness. And it was after the defense case, actually. And the jury came in with a very big verdict for us, for the plaintiff, the widow of the guy who was killed. And so I went up, it was 12-0. So this guy voted for me. So I went up to him and I said, what did I do that made you think I was tipping off the witness? He said, wasn't you, it was the other guy, it was opposing counsel. This guy thought that opposing counsel was tipping off the adverse party. You never know what's going to happen in a trial. The strangest things happen. That I was dumbfounded for a moment. Anyway, that's what you do if you're doing your direct.
Let's move on and to the case that we're going to focus on today, which is Don King Don King Productions, I should say, against Buster Douglas. John, can you give us a brief overview of the facts of the case? What was it about?
Well, what it was about, and I should tell you up front, I wasn't in on this case at the beginning. So none of the discovery was done by me. I came into this case very late. But what it involved was a dispute over the heavyweight championship fight between the champion, Mike Tyson, and the challenger, Buster Douglas. And the fight was held in Japan. And what happened during the fight was that Buster Douglas got knocked down in an earlier round. And he wasn't badly hurt. The count is given to the fallen fighter by the referee. The referee, who was a Mexican individual who spoke very good English, would lean over into the fighter's face, the fallen fighter, and count very deliberately, 1, 2, and not only would he do that, but he'd hold up fingers to indicate the number of seconds, 1, 2, 3, so on and so forth. Meanwhile, at ringside in all fights is a timekeeper, and the timekeeper would be counting too. But of course, the fighter's not looking at the timekeeper, he's looking at the referee, the fallen fighter, that is. Well,
and it's the referee that counts, correct?
And it's the referee that counts. Why they have a timekeeper, I'm never quite sure. But in any event, Buster was not hurt. And by 9, having taken a nice rest, he got to his feet. And the timekeeper at ringside had got to 13. And according to the timekeeper, Buster had been knocked out and Tyson keeps his championship. But the fight went on because obviously the rule is you take the count from the referee, not from the timekeeper. Well, one important point was that King was the promoter for both fighters, Tyson and Buster Douglas, which could, if he's not careful, put him in a conflict situation. Well, King, who is larger than life, was not constrained by any thoughts of appropriate conduct. And he immediately complained to the referee during the fight that Buster had been knocked out. And after the fight was over, complained to the Japanese boxing board that Buster had been knocked out.
Because he wanted Tyson to win because he'd make more money that way.
Well, Tyson was a big money bag for him. Tyson was world famous, knocked out everybody in sight, and was a big money earner. Wherever Tyson fought, the crowds were huge, and the pay to watch television was a huge amount of money. Buster, on the other hand, was a journeyman. He was never much of anything. He never trained, and he was overweight, and he'd gotten knocked out by a lot of different fighters, and he wasn't going anywhere as far as money bags King was concerned. And so he complained and complained. And Trump himself testified that King, they were sitting next to each other at the fight, that King was rooting for Tyson. So,
but let me interrupt you for a sec. The key issue is that Douglas got knocked down. He got up before the end of the count, he knocked out Tyson, and Tyson was then out, and Buster Douglas won the fight.
That's exactly what happened. As a matter of fact, King talked to me later on during the trial, and he said Tyson was in hospital after he was knocked out by Buster Douglas for like 4 days. Didn't even know who he was for 7 days. And he said to me, Buster Douglas could have been the greatest fighter in the history of the world. He absolutely slaughtered Tyson. The problem was he was always lazy. He never worked out. He never trained. So that's why he got beat by inferior fighters. This particular fight he trained for. And and he was in perfect shape. But what happened was the case went on for a couple of weeks and then ultimately was settled. And if you ask me what the settlement was, I don't know. I was getting ready for the next day's trial and was to call on the phone and said, we settled. But
I think
one of the things that happened.
We're getting a little ahead of ourselves, is that after Buster Douglas basically won the fight, King was protesting, was he not, that in fact Douglas had been knocked out because he had been down for more than 10 according to the timekeeper, and King, even though he was supposed to have duties to both boxers as the promoter, was very much on Tyson's side, and he upset Buster Douglas very much. Isn't that right?
Yes, absolutely. That's correct.
And so what was Buster Douglas' attitude to a rematch?
Well, Buster was a very intelligent guy, and he was infuriated by what King had done. He had tried to take away his title that he had won legitimately and honestly. And that led to the second issue, because in my view, King and Trump had violated the rule of good faith and fair dealing and breached their own contract, assuming they had one. But the question, there was no contract for Buster or the winner to fight anybody. Trump contended that during the fight, it became apparent after Buster had gotten up and continued to fight, that Buster was going to win. So he claimed that he and King made a contract for Buster either to fight a rematch against Tyson or to defend the title against Evander Holyfield, a top contender, at Trump's place in New Jersey. And you can put that on the screen, those questions, Zan, if you will, that I asked him, because I think they're significant.
Yeah, here it is. And let's not forget, just so everybody's aware, is that Don King and Donald Trump were sitting next to each other during the fight and were having these conversations. So we start, I think, around line 10, correct? This is
actually a little bit earlier.
This is you examining
about 10.
Trump.
The first issue that was big with me was proving that there wasn't any contract between them. And you see here where it says, was there any draft in this? No. Was there any confirming letter, any memo any place, or any notes made on a napkin, or anything in writing that would set forth anything about the fight? No, and I never have. I'm talking solely about this one now. No, there wasn't. And you committed, he had committed to, purportedly, to $12.5 million that he was going to put up so the fight would be there. And you committed to $12.5 during that short conversation during the 10th round. Absolutely, absolutely correct. Did you believe that Mr. King had in fact committed to you to have that fight? I did. I did believe that, absolutely. Now, what happened was, after the fight, King went back to New York and had a press interview in New York at one of the hotels. And in that interview, he was asked, I'm asking Trump this question on cross-examination during the trial. Did you learn that upon Mr. King's return to the United States, he was at a press conference in February 13 here in New York City, at which time he said he had no deal with you for such a fight. Answer at the Plaza Hotel. Yes, I heard that. I read that. And then I said, essentially, well, how does that wrap up? He said, well, he called King, and King said, don't bother with that. You know, we're talking about two skillful liars here. And he said, don't worry about that. We got a deal. That was just for them, blah, 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 blah. Still no writing, still no, even a short note or a memo. There's no documentation at all. And Trump claims he's on the hook for $12.5 million and claims he's got a deal. Well, that was that situation, and how the jury would have decided afterwards. They the few I talked to, what happened, the judge held us in there for some time to let the jurors go if they didn't want to talk to us. But a couple of them did talk to us, and they didn't believe anything King said and didn't believe anything Trump said.
We're getting a little bit ahead of ourselves here. I actually wanted to explore a little bit how, as you said earlier, you weren't in the case in the preliminary stages. Who did you represent, and how did you get to be hired?
Well, I represented the Mirage in the Trump case, or the King case. Earlier, some months earlier, I had represented a client tried a case against the Mirage, the jury case, and had won
totally unrelated, correct?
Totally unrelated. The only connection was the Mirage was in both cases, but I beat them in that case, and as far as I was concerned, that was the end of my relationship with them, with the Mirage. They were opposing party, but I got a call either from Steve Wynn, who was the owner of the hotel Mirage, or his general counsel, and they asked me whether I would be willing to go to New York for a mock jury and represent before the mock jury the position of King. And I said, sure, I'd do that. I knew nothing about the case, but I learned a lot. I met with general counsel and flew back to New York, and I did the mock jury. And when it was over, Mirage was represented by some New York firm, I've forgotten the name. Mirage asked me whether I would step in and not replace, but be the lead counsel. The other law firm stayed in, but they just sat next to me. So that's how that happened. So I'd taken none of the discovery and came in very late.
So how long before trial did you come in?
You know, Zan, I can't completely remember, but it was maybe we were doing a mock trial, so I had to be close to trial. Sure. I would say probably a month. I'm guessing.
Yeah.
It's been a long time.
And had you tried a case in New York before?
No, that was the only one I ever tried in New York. In
and
federal district court.
Were you frequently hired by people you'd beaten have you been frequently hired by people who you beat in earlier trials?
It rarely happens.
Yeah.
Being hired by somebody who you beat in a trial, it was, to my way of thinking, a real compliment.
It's a big compliment.
Yeah, it was a compliment.
So going into the trial on behalf of the Mirage, what was your strategy? What were you hoping to establish?
Well, again, I was a bit at sea. I was studying at every possible moment, but I was trying to prove that there was no contract between, because Mirage had not a contract with anybody. So it wasn't a question of whether there was or was not a contract as far as the Mirage was concerned. But I wanted to prove that there was no proof by preponderance of the evidence that there ever was a contract. The fact that they had no writing initially, and it was by conversation during the fight itself, and then later King denying that there was ever a contract, I don't think they established that. But the second thing I wanted to prove was that King, and with Trump's help, had violated the rule of fairness involved in every contract, whether in it or not, and therefore abrogated any contract, even assuming there was one.
Meaning his contract to promote Buster Douglas.
That's no, his supposed contract to have the first defense or the rematch at Trump's hotel. My feeling was that, first of all, there wasn't a contract. There's no indication, and King denied it. Second of all, he has abrogated the contract by his disloyalty and his violation of the fairness principle. And Trump had the audacity to say that by Buster coming over to speak to Steve Wynn, that he had not been loyal to King. And, you know, I gave one of these long stares at the jury at that one. And because
So how was Trump when it came time for you to cross-examine Trump? How was it? Was he a good witness? He's a difficult witness? How was he?
He was not as difficult as King. King never heard a question that he couldn't answer beyond yes or no. You ask him, does he have a car? He'll tell you how it was put together and how much it cost him, etc. And the judge would do nothing about it, would not control him. You could repeat your question, you could move to strike the answer. All the judge would, I'd say, Your Honor, Mr. King and Mr. Trump too, don't really know that they're only supposed to answer the question asked. And the judge said to me, I get that same impression, Mr. Scherer. Ask your next question. No bloody help at all. Absolute useless.
So what do you do when you're confronted with a witness who is being just completely non-responsive and giving off-the-wall answers? If you don't have a judge who's going to corral them in, what can you do about it?
Well, you try to repeat the question and ask the witness very carefully and slowly to please just answer the question. One thing you can do is to say, your counsel will have the opportunity to ask you any questions, so you don't have to get everything in now. Wait for him to question you, and maybe he'll ask you some questions. But I'm asking you specific questions. Please answer. The judge didn't interrupt me because I'm way out of line telling him that, but knowing that he wasn't helping me and he was going to keep quiet anyway. But you can do that. You can move to strike, or you can repeat the question. The problem with repeating the question is the answer, and if it was damaging, remains in the record. If you move to strike it and you're not successful, at least you try to get rid of it. And all you can do at that point, if you're not getting any help, and if the witness will not respond appropriately, is to prepare your record, make sure you prepared your record, because it could be grounds for reversal if you lost the case.
You have to look to the appellate issue, the appellate issues which you're building in as you're going along. But one issue I think where you were asking Trump was when he was sitting next to Don King during the fight, and I think you asked him whether or not Don King was actively rooting for Tyson, and he denied it, did he not?
No, he didn't deny it. He said he assumed he was. He wouldn't say he heard it, but he said he assumed he was rooting for him.
But the evidence had been from everybody else sitting around them that King was jumping up and down, screaming about, you know, Tyson had won the bout, and very visibly and audibly siding with Tyson, correct?
I think it's an opportunity to try to get the result reversed. And
so what do you do? What do you do with a witness when they're giving what you clearly know to be a false answer?
Well, if you've got impeachment material, and I emphasize the importance of impeachment material. I didn't take these depositions, so if you've got good deposition testimony, that's the most significant thing. And the way to do it is to find a good question and a good answer in the deposition, and then state your question live, word for word, as it appears in the deposition. If you don't do it word for word, you'll draw an objection. It's not impeaching. With King, it didn't have to be impeaching because he's a witness. You can use the deposition for all purposes. In New York and California, if it's a non-party witness like Trump, you can only use a deposition if it's impeaching. So ask the question word for word as it appears in the deposition. If he gives the answer consistent with that, move on. If he gives the answer not consistent, be sure you say to the judge, Your Honor, with the court's permission, I would like to read from the witness's deposition page, start line number, ending page and ending line number. Leave a second or two for the guy to find it, your opponent, and then the court will say, read it and read it. It's got to be done immediately, as quickly after the wrong answer as you can, because you lose momentum, you lose impact. So you can't be fumbling around looking for it. You got to have it ready.
Once you've read out or had read out the impeaching testimony from the deposition showing that his previous answer to the jury was false, do you move on, or do you try to use that inconsistency by commenting on it or asking a follow-up question, or do you just leave it alone and move on?
Leave it alone. Never ask him, well, now you said one thing and now you've said another. What's your explanation for that? You come up with some cockamamie explanation. You never give the witness, whether it be Trump, King, or anybody, in any sense, a chance to explain the inconsistency. The inconsistency is laid in the jury's mind, and move on to something else.
I think from my training at the English bar and my experience there, one of the key things was when to shut up and sit down. Do you agree that's an important thing to learn?
It's terribly important. Next to using the right vocabulary, it's the next most important thing. You've got to know when you've had enough, when you've got what you need. You can ruin a beautiful situation that you've created through your questioning by asking one too many questions. Always remember, one too many questions can sink you.
Moving back to the case, did you have any conversations with Don King in the breaks?
I had a conversation with him. I can't remember whether during the breaks or afterwards. He was very on my wall. Actually, I've got a picture. The courtroom artist drew a picture of me cross-examining Trump, which I've lost. I've lost that picture somewhere, but I have a picture of me cross-examining King, and King signed it for me. He was very gracious, really, and he complimented me and how I tried the case, and to my surprise, told me how he thought Buster Douglas was potentially the best fighter in the world.
And one thing that I really appreciated about preparing for this is that you recommended I read this book about Don King by a boxing journalist called Jack Newfield. It's called The Life and Crimes of Don King, The Shame of Boxing in America. And there's a long chapter about this trial, but it's quite fascinating. It is an absolutely searing indictment of Don King, who on the one hand is a certifiable genius, and the way that he, for example, held together the Rumble in the Jungle is exceptional, but on the other hand, are absolutely ruthless and predatory criminal who would kill two people, and you know, a fascinating, but in some ways, you know, repellent human being. But did that come across in the trial, or did you get the charm and all of the charisma?
No,
Did anybody manage to penetrate that?
The only thing with King was that he could never answer a question directly, and that was frustrating, and I was not getting any help. But other than that, I didn't have any trouble with King. King didn't threaten to kill me or anything of that sort. Matter of fact, he was very gracious with me, complimented me, and talked about how great a fighter Buster was.
So what happened ultimately? Did the case get decided? Did it go to the jury?
It did not go to the jury, to my utter surprise. Somehow or other, the parties had got together without the benefit of counsel, and they'd settled it between themselves. And as I say, I was in the office getting ready for the next day trial. We were getting pretty close to the end. when I got a call from either from Steve Wynn or from General Counsel saying it had been settled.
And
they
did you
never
know
told
the terms
me.
of the settlement?
No, the only thing I know, because it was obvious, was that the defense of his title, Buster Douglas, his title, took place at the Mirage, not at Trump's place. And I like to think that was because I was beating him, and I think I was. And unlike the Tyson fight, Buster did not train, came in overweight, and got murdered is the wrong word, but got knocked out by Evander Holyfield, and he immediately retired. So the whole case ended up being of no consequence, because the idea that you're going to have a long run with Buster Douglas and make huge amounts of money from 6 or 7, 8 defenses never occurred.
So there never was a rematch between Douglas and Tyson?
No, never was. I think Evander Holyfield fought Tyson. Can I make one comment on something you didn't mention, and that was opening statement?
Sure.
There are many top trial lawyers who will tell you that after the opening statements are over, the case is over. That jurors will make up their mind based on the opening statement. And anything that comes after that is a waste of time. Ironically, they're making their minds up without hearing one piece of evidence. All they've heard is voir dire, and they've heard opening statements. None of that's evidence. I won't go as far as to say that opening statements end the case, but I will say that opening statements are the most important thing in the case, because jurors do make up their minds. I think they will change their minds if there's strong enough evidence that causes them, but it's a big negative if you're coming out behind after opening statement. And so you better be sure. One of the things I wanted to say, you want to be nice, pleasant to court attachés, because they'll go to the judge and tell them what a jerk you've been and so on and so forth. Also, with respect to the reporter, what you need is your opponent's opening statement, so that if he or she doesn't prove what they said they were going to prove, and an opening statement is a promise, you can read to them. But if you're not nice, you don't have to stay up all night typing the opening statement of your opponent for you. But if she likes you, you might. It's another indication that you've got to do the right thing. But opening statement, the vocabulary problem again, you get, and try not to read your opening statement. Nothing is duller in the world than an opening statement that was read, and nothing is less convincing than an opening statement that's read. But
I want to read out a quick passage from your opening in this case, if you don't mind.
Okay. Sure. Go ahead, Zan.
Here's you. I will agree with Mr. Hurth, who was your opposing counsel, that this case is about greed, and it is about arrogance, and it is about power. But it isn't the greed, arrogance, and power of Mr. Wynn. It is the greed, arrogance, and power of Mr. King. It is the greed of Mr. King that is involved here in attempting to sacrifice the career of James Buster Douglas, because such sacrifice would be in Mr. King's best financial interest. It is the arrogance of Mr. King who changes his story, as you will hear, and the evidence will show from time to time and from day to day, when he thinks the story he told yesterday is no longer the story that best suits his purpose. It's the power of Mr. King who is able to have the governing bodies of the boxing world decide to withhold the title from Mr. Douglas, a title that Mr. Douglas had earned in the ring, that he was entitled to, that he was not entitled to have his promoter, the man who was charged with the responsibility of being fair and impartial and was not taking one side against another. He was entitled, that man, not to attempt to do what he did. And so it continues, but I just find your language here to be very powerful, and you're telling the jury very, very clearly and strongly what the story is. Tell me one thing, John, do you write out your openings, or do you just make notes?
Well, I think young lawyers are going to have extensive outlines, And as their experience increases, their outlines will get shorter and shorter and shorter. I can, and I know a lot of experienced lawyers can conduct a direct examination that goes on for 3 or 4 hours on a half a page of notes. And in closing argument, I can put key words, just words, 1 or 2 words for each issue. And I can occasionally glance over to take a look, but most of the time I don't have to look at it again. Young lawyers have written out all their questions and the proposed answers, and it's almost impossible, and in opening and closing, it's almost impossible not to read it when you've done your outline in that fashion, and that's very boring, and the jury will tune out.
I would suggest, though, sometimes, for example, in depositions, if you have a motion for summary judgment in mind, that it is sometimes a good idea to write out those questions so that you get in the record exactly the terminology that you want, and hopefully, obviously, the answers you want, but that's probably the exception. But tell me this, how important is listening? I mean, if you're reading, you can't listen, correct?
Well, that's true. If your adversary is examining or cross-examining, it's not time to check the Dodger scores or Chelsea versus Fulham in our case. It's time to concentrate because you have to multitask. You have to be watching the jury while your adversary is questioning the witness to see what jurors' reactions are to the testimony, who's writing stuff down, whose facial indications are an indication that they are accepting the testimony or not. Then you've got to be thinking, because questions and answers are coming in, is there something in your deposition you need to find? Is there some exhibit you've got to use? And all the time, you've got to be ready to do your cross or your redirect or whatever it is, and making notes and finding exhibits. So it's a very busy time when you're not actually questioning the witness, when your adversary is. That you should be busier than you are when you're actually questioning.
We've gone well over the hour now, and if everybody's still with us, that's great. But I want to move on just to finish up, John. There's a few things which I'm really keen for us to touch on briefly. And the first is that I believe that in your 80s, you tried for the first time a criminal case. Could you tell us briefly what the circumstances were of that?
Yeah, a black former state trooper in Alabama was convicted of having killed his wife for insurance proceeds. And we got into the case after his remedies and his appeal rights had all been exhausted under Rule 32 in Alabama, which post-conviction stuff. And we discovered over the course of years that much material, exculpatory material, had been withheld.
He was on death row, was he not?
Pardon me?
He was on death row.
He was sentenced to death. He was on death row.
So you took on what, on a pro bono basis to try to get the conviction reversed?
Well, after years and years, we found a lot of exculpatory evidence, some of it unbelievably poignant. And we had a very good judge in Mobile, one of the best I've ever been before. He wasn't the judge who tried the case. That judge had died. And he granted a new trial after we've been in the case like 6 or 7 years or maybe more. And the case went to the Alabama Court of Criminal Appeals, who affirmed, and the Alabama Supreme Court denied cert. Then we moved to dismiss the indictment, and the trial court grounded it. And the Court of Appeals affirmed. The Supreme Court reversed and said we could still get a fair trial. So sent it back to retrial, to be retried. And we did retry it, and he got convicted again. He had been out 4 years. The judge had put him out on bond. As a matter of fact, somewhat amusing story, not amusing, but my colleague, Zatharina Perez, who's helped me through most of these years, was getting married in Los Angeles. She wanted our client, this former police officer, to attend the wedding, and the judge allowed it. And he stayed at my house, this house, with, and went to the wedding, and then went back the day after the wedding. But the case is now in, because the conviction has been affirmed all the way, and the Supreme Court affirmed it. We're in federal court in Alabama on a habeas writ, which is, we filed our replies almost 6 months ago, and we've heard nothing. But hopefully, the 11th Circuit has made some interesting rulings, although this is not the jurisdiction you want to be in when you're being charged with a crime. They're it's the most red state in the union. But it is what it is. It's still going on. I've been handling this case for 16 years. Maybe the longest criminal ongoing case in history.
I mean, you have this great tradition of, pro bono, taking pro bono cases. I believe you've received a couple of awards.
Yeah, from public counsel. They're up on my public counsel, counsel of the year or something.
Yeah.
Twice I got it. It was very, very satisfying.
And now you're also a published novelist. I think you've had 3 novels published.
Yeah, I do have 2 for adults. Honor Knows No Borders. It's loosely based on my own experience in London during the war, and my father's experience as a staff officer, a British officer in the desert. And my second book was The Cockney Lad and Jim Crow. I again, loosely based on my own experience as the Cockney Lad. And then recently I wrote a children's book called Ants Don't Talk. They've all been published, and they haven't made the New York Times bestseller list, but a lot of people like them.
They're wonderful books. John, anything else? We've gone over time a little bit. Is there anything you think that we should cover that we haven't covered so far?
Let me just.
We could keep going for a couple of hours, but people have places to go and people.
No, I understand, and I won't keep them. Did I mention the nun? Oh yeah, I did. Yeah. I won't get back to that. But I'll end with a funny thing. I had represented a major national dance studio company who, I won't mention the name, but people can probably figure it out. And they were accused, their individual dance studios would enter into lifetime contracts with people. And some of these people were pretty old, and there were lawsuits brought on it, and they were difficult cases to defend. And there was one case, this old postal deliverer who never made more than $8,000 a year had signed like 3 lifetime contracts with this studio and got the appellate decision. We avoided punitive damages in all these cases, which was the great victory. And the judge started his appellate decision saying, canny old Mr. Porter, having skillfully got his way into dancing into the 32nd century. I thought to myself, geez, we're in trouble. But the cases were mostly in San Diego. And in those days, you didn't have a judge for all purposes. When the trial date came, you went into Department 1 and you sat around until a courtroom opened. And every time I'd walk into Department 1 full of lawyers to wait for a judge to break open, they'd all jump up and start pretending they were dancing around. So having said all that, I think I'll go see if my dance steps still work and dance on out of here.
John Scherer, it's been a huge privilege. I love you. I think you're a wonderful guy. I'm so pleased we managed to do this. And now we can both go off and watch Chelsea against Fulham. Anyway, this has been far more enjoyable. Thank you so much. And thank you to everybody for logging in today. I hope you've enjoyed it as much as I have. John Scherer, thank you so much.
Thank you, Zan.